my take on sovereignty in a digital environment, probably, I mean, my take is there's probably no sovereignty in a digital environment because we don't control the digital, right? So the best sovereignty is community, physical community, not digital community. Because they can just, I mean, they already do it. They censor my page. They censor people I mean, whatever topic they may be telling the truth on. It don't have to be about law. It could be about, technology or food or whatever. On the internet, there's no sovereignty because they can censor your page because we're on other people's platforms. These aren't our platforms, you know what I mean? So unless we come together in person, then I mean, I don't think there is none. And then they're going to create more. It's not censorship, but they're gonna create more compliance online. So like they're gonna make, eventually it'll be digital, IDs or digital verification or whatever. All that type of stuff will be mandatory. It'll be mandated. I'm assuming that's what you're talking about. I guess that's what you mean by sovereignty in a digital environment. Yeah. The best digital sovereignty is building your own website. Well, all IDs are the same, whether digital or physical. So you have to rearrange your life so that you don't have any IDs. Because all IDs are fake. And somebody else creates them. So we don't have to talk about digital ID. We just have to rearrange our life so that we don't have no IDs. Because all IDs are legal fictions, which somebody else created for their benefit, not for ours. What's up, everybody? What states are we from? What states are we from? Florida's in the house. Colorado's in the house. Let's go. Indiana's in the house. Let's go. Texas is in the house. Let's go. Let's see. Indiana, Texas, Colorado, Florida. Let's go. Any questions? Any questions? Texas, Indiana, Colorado, Florida. I thought somebody said something else. But it's not. Let's see here. I gotta find more Indiana stuff. I like Indiana. Indiana's constitution is pretty nice. I like that. Indiana joined the Union on December 11th, 1816. And they said that the people of Indiana formed a constitution and a state government. And they formed for themselves a constitution and state government. And so formed, it is Republican. The principles, conformity with the principles of the Articles of Compact between the original states and the people in the territory of the northwest of the river Ohio. And Indiana shall be one and is hereby declared one of the United States of America and admitted into the Union on equal footing with the original states in all respects whatsoever. You know why they do that, right? They tell you, okay, so when you start studying law or at least federal law. So joining the Union after the original 13 states is a federal act. Why? Because the federal Constitution was created 13 years after the Union had already started. So the Union started with the original 13, right? They existed for 13 years, independent, no feds were created, right? Then the federal Constitution gets created, and that gives the federal corporation powers, right? So they have powers through the Constitution to admit new states into the Union. They do not create states. It's very important, right? They didn't create Indiana. Indiana, they tell you, that the people of Indiana formed a constitution and a state government. Who did it? The people of Indiana did it. The people of Florida did it. The people of Colorado did it. The people of Texas did it. They formed a constitution and a state government. And they said that Indiana shall be one and is hereby declared to be one of the United States of America. The United States is not a nickname for the United States of America. The United States is the name of the federal government. Does that make sense? It is the name of the District of Columbia. Indiana joined a union that consisted originally of 13 states, and that union was called the United States of America. They said that in the Declaration of Independence on July 4th, 1776. They said, as I pull it up, okay? The unanimous declaration of the 13 United States of America. Okay? So that was the name of the Union as of July 4th, 1776. And so Indiana is not part of the United States. It's not a state of the United States. It shall be one and is hereby declared to be one of the United States of America and admitted into a union. So what is the United States of America? That's the name of the union. That's just the name of Alabama, Alaska, Arizona, Arkansas. Okay. But the United States by itself is just the District of Columbia. It's supposed to be an international representation of the 50 states collectively, right? So and I'm not telling you to do this, but okay, this is in the United States Public Statutes at Large. That is the official legislation of the United States government, the federal government, the federal corporation, whatever you want to call it, right? That's it. Technically, that exists. Outside of this citation, which admits Indiana into the Union, there is no other statutes pertaining to the people of Indiana. They don't call them the United States citizens in Indiana. They said the people of Indiana. And then, okay, cut to the next scene. The next scene would be the Constitution of Indiana, right? Let's see. Indiana Constitution. Let's see, how do I find it real quick? See, they want to give you a freaking PDF version. I don't want the PDF version. All right, the preamble of the Indiana Constitution. They said the people of Indiana. Okay, well, you don't find any other statute in the United States statutes at large where they're addressing the people of Indiana. Does that make sense? There's no federal legislation talking to Indiana. If it mentions Indiana ever, and I don't know nothing about Indiana, then it will be talking about federal things inside of Indiana, like a national park or a mountain or a river or something like that. I don't know nothing about Indiana, but whatever national parks you may have in Indiana, or historical sites like I don't know, an ancient war trail or something like that. Okay, well, there's nothing in the United States statutes at large talking to the states. And this isn't the original Indiana Constitution, so I don't know when 1816. Let's see. Indiana, I think Yale would have it. Yale, I forgot what they called it. Indiana Constitution. 1816. I forgot the name of the website where they have all the original Yale. Yale 1700s. Oh, I know where I'll find it. Avalon, that's it. I can never think of it because I'm never on their website. But all right, so we go to the 1900s, and then we're gonna search Indiana. They said Indiana was not here. Where's Indiana? When was the first Indiana Constitution? First Indiana Constitution. 1816, June 10th. Right, but I want to see it on Avalon. I don't know why Avalon wouldn't have it. Or did I spell Indiana wrong? Nope. Ooh, they got the Louisiana Purchase on here. But anyways, you get my drift. Here we go. You're right. See, the people of the territory of Indiana. There we go. Oh, yeah, I like that. Yep, they do ordain and establish the following constitution or form of government. So what does a constitution do? It creates a government. It created 3 branches of government in Indiana. They got executive, they got legislative, they got a judicial, right? And they said they are a free and independent state. Boom, that's it. Right? So you got December 11th, 1816. And then when did this happen? June 10th. Okay, so who created the Indiana Constitution? Not the feds. The feds weren't there. The feds didn't authorize it. The feds didn't give it permission. They said, okay, we reviewed it before you entered into the union, and we found it to be a Republican form of government. That's it. Because they do have to review it to make sure it's a Republican form of government, so that when they enter the union, the people retain their sovereignty, right? They said, okay, the people of Indiana form for themselves. They said we weren't there. We were nowhere to be found. They said the Constitution existed before they joined the Union. They said, technically, Indiana was independent. right before, because they were a federal territory, but right before they entered the Union, they were independent. And they say it. They are a free and independent. I clicked out of it. A free and independent state. And then the feds reviewed it and said, cool, bet. And then they got admitted into the Union. So what is Indiana today? A free and independent state. No, but I thought they were one of the Nope, not like that. Indiana do what they want to do. Actually, I do have this. I have one that says, Indiana has a Supreme Court case that says they're not United States citizens. I forgot about that. Dang it. Where is it? Because I remember I debated an attorney on it and he couldn't refute it. So I said, oh, so the Indiana Supreme Court's wrong? And he shut up. He couldn't say nothing else. I was like, yeah, shut up. I forgot about that. Dang it. Now I have to go find it. I know it exists. Dang it. Where would it be? It would be in the citizenship thing, I guess. But that, you understand? Okay. Indiana created their own constitution. The Fed said it. They said they formed themselves a constitution and a state government. And they found it to be Republican in the principles of the Articles of Compact between the original states and the people in the territory of the Northwest River, Ohio. And they said Indiana shall hereby be one of the United States of America and admitted into the Union on equal footing with the original states in all respects whatsoever. What does that mean? That means when they joined the Union, they got treated just like the original 13 states. They were not bound. They were not subjected to there was no federal government. So they're treated just as if there was no federal government and it was just an independent state. And then you were in a union of independent states. That's what sovereignty means in America, right? Now, because it is in the union and the union has given power, some, not all, to this federal corporation, then it doesn't have absolute sovereignty, right? Indiana does not have, for instance, admiralty and maritime jurisdiction. Indiana doesn't have commercial powers. Why? Because the feds regulate commerce. Because the feds only have admiralty and maritime courts in America, right? But as far as sovereignty of the people, that's never been taken away. And as far as the legislation of Congress in the District of Columbia, they never talk to the people of Indiana. Now I can't find the case. Dang it. So you got to be able to prove everything. But yeah, I know I got a case that says, okay, well, technically, Indiana aren't United States citizens. There's no such thing in Indiana. You may come from the District of Columbia to do some work in Indiana, and that may be a United States citizen. But to people who were born in Indiana, people who are domiciled in Indiana, okay, well, the legislation of Congress doesn't apply. Or whatever state. We're just using Indiana as an example. Somebody said, what is the difference between a constitution and a bylaw? Well, a constitution creates a government, and then for instance, the Constitution creates a legislative branch, and the legislative branch creates bylaws for the operation of that corporation. But Indiana is its own thing, just like Florida is its own thing. Right? And technically people in Indiana they're called Hoosiers. Y'all know that? Nope. People in Indiana are called Hoosiers. Hoozier. What other states? What other states? All right, so the Supreme Court of Indiana says that the people of Indiana are the exclusive judges of the evidence and determine the law. They said at common law, the jury in criminal cases are the judges of the law, right? Supreme Court of Indiana said the common law of England may properly state and define many attributes and powers of sovereignty which are applicable to this republic. They called themselves a republic. They say it. They say the common law of England may properly state and define many attributes and powers of sovereignty which are applicable to this republic and to our several states. They say Indiana is its own thing. They said the source of all governmental power in this state is the people. They said any sovereign prerogatives Indiana may have come from the sovereign power of the people. Dang it, where is it? I'm going to find it now. What else? Any questions? Any questions? Boom. Perfect. Correct, Charlie. The dude from Indiana, the Supreme Court of Indiana said, let me go ahead and tag Indiana in this. I'll be slipping. Oh, it is. It's already there. All right. The Supreme Court of Indiana said that this guy was not a citizen of the United States. He was a citizen of Indiana. And it said under our state constitution, one may be a citizen of a state and yet not a citizen of the United States. And then they cite 1, 2, 3 Indiana Supreme Court cases and then a Wisconsin Supreme Court case out of a Indiana Supreme Court case. So they say he was not a citizen of the United States. He was... And they said that after the 14th Amendment. So when a Fed gets in the comment section and says, oh, it gave everybody dual citizenship, and the Supreme Court of Indiana said, no, it didn't. Okay, well, Indiana knows what it's talking about. That's the same thing I told the attorney. I was like, so the judges in the Indiana Supreme Court don't know what they're talking about? They're just uneducated fools, huh? Yeah, he got real quiet after that one. They said the 14th Amendment is irrelevant here after the Civil War, after the 14th Amendment. There was no such thing as a citizen of the United States if you were born in Indiana. Yeah. What else? Give me some other states. The Supreme Court of Indiana said the jurors, they said a trial by jury is not a trial by judicial officers. They said the jurors are the people. They said in this country, in the same case, in this country, the sovereign is the people. They said it is clear from the early history of juries, they were considered merely members of the community, representative of the people. They said we had representatives, y'all. They were called the jury. All this stuff is nasty because they want you to think, oh, well, your representatives are in D.C. and in the Senate and in the House of Rep. Nah, not in Indiana. They said, no, we got representatives. Thank you. And if you pass an unconstitutional law and a law that violates the common law of England, okay, well, when it comes before us, we're going to veto that thing. They say, yeah, we don't care what y'all are doing in D.C. What goes on here is the law. And we'll do it every single case because we're a community and we talk to each other and we're not doing anything that violates other people's rights when there's no injured party. See, they said, see, this stuff is nasty because they'll tell you, oh, well, you have a representative in D.C., so that means we get to take magical money out of your paychecks every week. Nah, no thanks. They said this in this country, the sovereign is the people, not the people in Congress, not the ones in the House of Representatives, not the senator. He's not sovereign. The whole case is talking about juries. They said, don't worry, when it gets before us, we'll handle it. They said, it is clear from the early history of juries, the people, the members of those bodies were considered members of the community, representative of the people, as distinguished from office holders. Just in case you think I'm just misinterpreting the Supreme Court case, they make it very clear that the jury was distinguished from office holders, and they were members of the community, and they represented the people. They said a trial by jury was considered a trial by the people, as distinguished from a trial by a judicial officer in a black robe. Yep. They said you want to see the display of sovereignty? Bring it before the jury. Teach them the law and the facts concerning your individual case. Because they want you to pay attention to what's going on in the District of Columbia. But if you live in a state, it's irrelevant what's going on in the District of Columbia. Because what goes on in the District of Columbia don't apply in Indiana. Oh, this is nasty. We'll get in trouble. We'll get in a little trouble. See, I be hearing all these scammers and people on the internet talk about all you got to do is... Nah, all you got to do is bring it before the jury and know the law. That's it. They said the jury in criminal cases are the judges of the law. So who are the judges? I'm talking about, I see all these scammers talking about, oh, when you get before the judge, and they're talking about a guy in a black robe. He's not the judge of Indiana. They said that the people are the judges. They said the common law of England is the law of Indiana, not statutes, codes, regulations, and ordinances. I'm just using Indiana as a example. But y'all won't give me no other states, so. Right? They said under our Constitution, we don't have no king. So we don't know who these people think they're magically telling us what to do. We don't work for them, and they clearly don't work for us. They say in this country, the sovereign is the people. My neighbor is jamming, y'all. I don't know what he got planned, but it's bumping. What's up, y'all? What states? Give me some states. Give me some states. New York is bad. No. The New Yorker is ignorant. New York ain't bad. New York is one of the nastiest states for the law. I go over New York almost every day. New York got the nastiest cases, bro. We just got to get to learning. We've been procrastinating. We've been ignorant. We've been watching TikToks. We've been watching scammers on the internet. We've been blaming the government. when all the power relies with the judges in the state. We have a legal judicial branch of government. They are not Article 3 judges. What you don't have no Article 3 judges. What state are you in, Mr. Copperhead or Mrs. whatever? Here we go. Who are the judges of New York? They said in 1735, the issue of the jury's right to decide questions of law arose. This guy was charged with a seditious libel. This is the Supreme Court of New York. They said at his trial in New York, this guy named Alexander Hamilton argued to the court that the jurors had the right beyond all dispute to determine the law and the facts. They said that in New York, they've been trying to mandate to get rid of the nullification. That's right. We got to learn the law, baby. These Supreme Court cases don't be lying. We just don't be reading them. They said in New York, they've been trying to get rid of the nullification conduct, but they said the people can do what they want. And they cited three New York Supreme Court cases to validate that. They said it's long been recognized that it is the jury's duty to be governed by the instructions of the court as to all legal questions, but they have the power to do otherwise. So who are these illegal judicial branch? You're not supposed to be talking to these people. The Court of Appeals is the highest court in New York. No, every time you go before the jury, that is the highest court in New York. See, they want you paying attention to them. I'm literally telling you that the Supreme Court said that the jury has the right to decide questions of law. Alexander Hamilton said that the juror had the right beyond all dispute. That sounds like a Supreme Court to me. See, they tricked us. They said in New York, the people are the judges. They said we never told the guy in the black robe that he was a judge. His name is magistrate. His job is to handle paperwork and conduct ceremonies. They said, but when it comes to the law and the facts, the jury had the right to do that. Look, they said in another case. That wasn't in 1856. That was in 1998. They're citing Alexander Hamilton above all people. They said in a criminal prosecution for a libel, the jury shall have the right to determine the law and the facts. They said that in the 60s, not in 1792. This is the Supreme Court of New York. They said in every criminal case upon the plea of not guilty, the jury may, indeed they must, take upon themselves the decision of the law as well as the fact. They said the law and the fact are so involved that the jury are under an indispensable necessity to decide both. There's no such thing as representing yourself. Either you're there or you're not there. Michigan, they are completely illegal entities of the Bar Association. Like I said, traitors. But did you go to the judges or did you go to the Bar Association and teach them that the Michigan Bar has been corrupt and could prove it logically? I don't think Alexander Hamilton was ever a president. I think he tried. Didn't he die? We got to watch the play, everybody. I'm just kidding. I think he was the first Secretary of Treasury for the Feds or something like that. Michigan, let's go to Michigan, everybody. Now, I don't have who are the judges in Michigan, but we do know what the law of Michigan is. So we just told you who are the judges of New York. You know who the judges of New York are? They're not guys in black robes. I'm sorry. So if you've been going to them, that was because of our ignorance. Not because you obeyed the law. That's not the law. All right. Michigan common law. The common law shall remain in force, and the common law has been adopted into our jurisprudence. That's the Supreme Court of Michigan. They said the common law prevails in Michigan. They said this state's common law has been adopted from England, and to identify such law, this court may consider original English cases and authorities. They said the common law was adopted as the law of this state upon statehood and has since remained the law of this state. That's the Supreme Court of Michigan. Who are the judges at common law? Especially in a criminal case. Who are the judges at common law? Where do you think they got a trial by jury from in the federal Constitution? They got it from the common law. And at common law, the jury were the judges. They said the common law was adopted as the law of Michigan. So what's the law of your state? They said in another case that since Michigan became a state in 1837, Michigan's jurisprudence has recognized the pre-existing common law concept of sovereign immunity, which immunizes the sovereign from all lawsuits to which the state has not consented. Who's the state? The three branches of government in Michigan are not the state. What does the preamble of the Michigan Constitution say? It says the people. What is the purpose of government? To serve the people. So who are the judges at common law? Washington State. What is your nationality? One of the 50 states. That's my nationality. One of the 50 states. Everybody say it. Somebody said that their nationality is Washington. Someone said their nationality was Massachusetts. Let's go to Massachusetts. Somebody said their nationality was New Yorker, Virginian, Texan, Indianan, Floridian. That's the nationality. Sellouts. No, we didn't sell anything. Ohio, OH. Dude, that's what happens when you don't know the law. Because he wants you to think that because he's black, then he's magically a Moor. But they don't tell you that at common law, the Anglos and the Saxons trace their lineage and ancestry back to the people of Moses. And that in ancient England, prior to William the Conqueror, there was a mixed group of white and black people. Yeah, they don't tell you that, do they? But we're the sellouts. Right. Massachusetts said that the legislator is bound by the Constitution of the state. They said the legislator of Massachusetts is in no just sense sovereign. It is but an agent with limited authority, and it cannot rightfully transcend the bounds fixed in the Massachusetts Constitution. Who is the sovereign of Massachusetts? Because they said it. They said it, not me. The Supreme Court of Massachusetts said that the legislator, the people who write the statutes, are not sovereign. Oh, I found it. I was looking for this the other day. I thought I was. No, this ain't it. But I'll read it anyway. Look at this. This is the Massachusetts. When Massachusetts became a state, Massachusetts was one of the original 13. So Massachusetts said that Massachusetts then on becoming independent, was as complete a nation as France. They said Massachusetts and France, they're both nations. You know how crazy that sounds? No, but Massachusetts is one of the United States. That's not what they said. They said Massachusetts is as independent as France. Michigan is a nation. All the states are nations. That's why all the states have flags, have their own flags. You know where those state flags came from? They were the, what do they call them? The coat of arms for the different states during the Civil War. They didn't have state flags prior to the Civil War. But after the Civil War, they took the, what they call the coat of arms, or maybe I think it's called it's part of the original seal of the state militia. Okay, this is another topic for another day, but I got to study it more. But the state militia is a nasty, nasty concept in the Constitution. Technically, I don't want to get in trouble. I can get in trouble for real. But, okay. Let me read this first. I don't want to get in trouble. All right. Massachusetts said they're as independent as France. They said they possess the same absoluteness of will as well as supremacy and exclusiveness of control over her territory. They said it is necessary that the purpose of forming a new government in this province on the authority of the people only. Who are the sovereigns of Massachusetts? Who are the sovereigns of Ohio and of Washington State and whatever state you live in? They go to Pennsylvania. Now Pennsylvania said, let me grab the mic. They said the oath prescribed for the members being as follows. I, insert their name there, do declare that I do not hold myself bound to bear allegiance to King George III, and that I will steadily and firmly oppose the tyrannical proceedings of the King and Parliament, and to establish and support a government in the province on the authority of the people only. They said, to the people of Pennsylvania, friends and countrymen, in obedience to the power that we derive from you. They said we're becoming servants. And they say by the phrase and quotations sovereignty, I do not mean government. Because they said the word sovereignty has but one meaning, and that is the supreme and uncontrollable authority. Hence, it cannot be predicated on the so-called government or the powers of government in a republic. They said these must always be subject to the organized people, the Commonwealth. Isn't that nasty? Look, this is some nasty stuff, y'all. They say, as sovereignty in a republic necessary includes the right to establish, amend, and abolish governments, it is simply absurd to say that a government in a republic is sovereign. Why? Because you got to study a republic. In the federal constitution, I talk about this all the time. In a federal constitution, they talk about Article 4, Section 4, that the feds are to guarantee to every state in the union a Republican form of government. Okay, well, a Republican form of government doesn't mean that Donald Trump is the president. That's not what a Republican form of government means. Now, understand this. To understand the Constitution, you have to go to the common law. That was the thing they wanted. That is the reason they fought the Revolutionary War. Because what they said, king and parliament tried to take away the common law of England. And so they said, we declare independence so we can keep the law that we wanted and that the government was not obeying. Right? And what were the two principal things of the common law? Due process and a trial by jury. They said, we want that above all else, and we're dropping bodies over it. And so they got the common law of England as their law. No, republic does not mean representative democracy. Again, as I'm explaining, the Republican form of government, when they got ready to break off from England, they had been under a monarchy their entire existence. So they didn't know originally what it meant. So the preachers of the day went to the first 10 books of the Bible to understand what a Republican form of government meant. They said a Republican form of government they got from the first 10 books of the Bible, because if you study the first 10 books of the Bible, that family called the people of God did not live under a secular government. They operated as one family and up until a certain point, obey the voice of God. They didn't get a king until 1 Samuel, King Saul. And they got King Saul out of their disobedience to not obeying God's law. And I think it was Joshua. I don't know which king it was or which father it was of the family. I think it was Joshua. Well, they said, or Samuel, I remember. But when they got ready to get King Saul, it was because the people begged essentially for a secular government. And as a result, God gave them King Saul as a punishment. Because they said, give us a king to judge us like all the nations. Actually, I have this. It's 1 Samuel 12:17. They got books about this stuff. I'm not making none of this up. They said the reason we called it a Republican form of government, it didn't have nothing to do with voting. They said 1 Samuel 12:17, your wickedness is great in asking for a king for yourselves. And I'll read it. I got it. I don't have to prove nothing to nobody. But the first 10 books of the Bible, they didn't have a secular government. They obeyed the elders and leaders of the family. And so that's where we get a grand jury from. Because at the common law, in ancient England, the elders of the community would be the ones to start the case. And if a case was commercial and didn't involve an injured party, they would throw it out. And then if a case be valid, then they would bring it to what they call the petite jury. Okay, where'd they get the petite jury? The petite jury was the 12. Okay, well in the Old Testament, they got it from a dude named Jacob. Jacob changed his name to Israel. Israel had 12 sons. He taught 12 sons the laws and the facts. And then you get to the New Testament, they say in ancient England, they got that from the 12 patriarchs or the 12 apostles. Why? Because there was a dude named Christ. And he taught the 12 the law and the facts. And then afterwards, he said that they would be the judges of the nations. Right? So what's a Republican form of government? Oh, I got the picture above my head. I don't have the camera on my head. What's a Republican form of government? I forgot this picture was even up here. Where the sovereignty is based in the people. See, you see, I'll be forgetting I got this stuff up here. What's a Republican government? That comes from Article 4, Section 4 of the Federal Constitution. Where sovereignty is vested in the people and exercised by the people directly. Where is that? How is that done? Grand juries, trial by juries. The United States Supreme Court said a grand jury is not even part of the court system. Technically, to them, all courts are commercial. So when they say the grand jury is not a part of the court system, okay, well, they're speaking on the sovereignty of the people through the grand jury. And then when a case gets before the petite jury, the 12, okay, well, they determine the law and the facts. We just read it in the Supreme Court of Indiana. Right? So when they're setting up the countries, or they're setting up the states, which to them was the same thing, they said sovereignty in a republic includes the right to establish, amend, and abolish governments. And it is simply absurd to say that a government in a republic is sovereign. And they got a book on this. They got a little, I don't know what you call it, a little chart. The people as sovereign communities was above the name of the states. They said New Hampshire, Massachusetts, Rhode Island, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, Georgia. They said the people as sovereign. This is their law books. I didn't come up with this stuff. And then they got the Constitution under that. Then they got the government under that. He said the church is a business. The church you go to may be a business. But according to the Bible, you can't go to church. You could only be the church. So if you go to one that's a business, that's on you. Just like the sovereignty is in the people, well, the church is not a building. The court is not a building. The church is the people of God. Read Madison's notes of the convention and read what the founders said. I read what they said in the Declaration of Independence. Wisconsin's in the house. Michigan is a nation. Yes. The paper is the court. Nope. That's why we have a trial by jury. That's why we have a grand jury. See, all the feds start showing up when you start telling the truth. Oh, we got to get in the comment section and start derailing the conversation. He's telling too much truth. They start looking up this stuff. Yep. I'm going to do it one day. I'm going to pay to challenge any attorney face to face. And we'll talk about anything. I'll put 10 grand up. And they're going to have to prove everything they say in front of a live audience. And they won't be able to do it. Not when I get there. Because they're all liars. All of them. So again, the Supreme Court of the United States concerning Massachusetts said that the legislator is bound by the Constitution of the state. The legislator of Massachusetts is in no just sense sovereign. It is but an agent with limited authority. It cannot rightfully transcend the bounds fixed in the Constitution. All churches is a business. It goes back when people was fighting with the swords. Again, the church they may have went to. The Bible don't say go to church. No, it actually says sell everything you have, live in community. And it says do it even the more so as you see Christ's return coming. The word, see, we have to define the word. We don't even know what the word church means. The word church is the word ecclesia. The word ecclesia always means the people of God. So who do we go to if you think the government killed somebody in your family? You go to the jury. You go to the grand jury. Now, as easy as I'm saying this, I don't think I'm naive and I don't think there's government corruption. right? I wouldn't primarily be talking if I didn't think there was government corruption, right? So I'm not naive. As easy as I'm saying something don't mean it is as easy as it can get done. But who are we supposed to be going to? We're supposed to be going to the grand jury. And we're supposed to be bringing this case to the trial by jury. So just because I'm saying, oh, well, all we got to, no, don't ever think that. Everything, if that was the case, then it would have been getting done by now. Who is the grand jury of Michigan? Well, you need to find that out through whatever your nearest court is, or the court where the issue happened. What else? What other states? Due process. Yep, that's what the common law is. You want to know what the common law is? Common law is, in a nutshell, excuse me, due process of law, which I'm going to read what that means, and a trial by jury. That's what it is in the nutshell. Read Black's Law Dictionary, read the Constitution, read federal laws, and look at your state laws. No, just study the common law of England. Read your state Supreme Court cases. Missouri, 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 Missouri. I got too many tabs. Let me close some tabs. Let me close some tabs. What is the law of Missouri? The common law of England was adopted in Missouri on January 19th, 1816. They said the common law of England, which is of a general nature, made prior to the 4th year of James I. The common law is the rule of decision in this territory. So they're talking about before Missouri became a state. They said when Missouri came into the Union, it brought with it the common law of England. They said the statute by which we adopt the common law of England specifically includes the common law in force prior to the 4th year of James I, which was the year 1607. They said when Missouri became a state, it created a new governmental structure, including its judicial system. The new courts of Missouri necessarily started with no body of law of their own. They said they provided the state with a body of decisional law consisting of the English common law as it existed in 1607. And they said this section does not state that the English common law was enacted as a statute to be treated as a part of the statutory law of the state. It states that the common law shall be the rule of action and decision in Missouri. It says, they say it again, it says that the English common law as of 1607 was to be the decisional law of Missouri. So if I ask you, what is the law of Missouri? But they cut that live stream down, didn't they? It was 40 people up there. That's the most I had in a minute. They said, oh no, cut that thing down, baby. Cut it back down. They said, nope, hit the censor button. Hit the censor button. They said, nope. No telling the truth here. Don't get the people thinking. Supposed to be on TikTok for distraction. Nope, the common law. Missouri don't call itself a commonwealth. Missouri, the common law is the law of all the states. I literally can prove it. I literally can prove it. I'm literally proving it. Missouri doesn't call itself a commonwealth. There's no such thing as, oh, well, there's the only difference is Louisiana and their criminal law is based on the common law of England. So there's no state in this union that does not have the common law. No state. So again, I ask you, what is the law of Missouri? Illinois. Let's go to Illinois, baby. They think I'll be playing. They think I'll just be making up stuff, bro. I love it. Said the common law is only. No. Common law is in every state. Ooh, here we go. I asked the question. Who are the judges of Illinois? They said all trials for criminal offenses according to the course of the common law. They said the rules of evidence, of course, according to the course of the common law, shall be binding upon all courts and juries in criminal cases. Juries shall in all cases be judges of the law and the facts. Who are the judges of Illinois, y'all? They said not until 40 years after the adoption of the Constitution of the United States, the jury is still the judges of the law and of the facts. They said the Supreme Court of Illinois said that Illinois adopted the common law of England as it existed prior to the 4th year of James the First. Watch this. Now, this ain't, I'm telling you, I'm not reading cases from 1846. I'm reading, this is 1993. Illinois said that the common law of England and all statutes and acts of British Parliament prior to the 4th year of James the First, not local to the kingdom, which means in benefit of the people, shall be the rule of decision and shall be considered as in full force. What? They didn't tell me that. They told me that the Illinois Code was the law of Illinois. No. What's the law of Illinois? The common law of England. They said another, that was in 1993. In 2004, they said Illinois has adopted the common law of England made prior to the 4th year of James the First. Nope. Everything I'm talking about is the common law. When I talk about a jury, I'm talking about the common law. When I talk about a crime, I'm talking about the common law. When I talk about the history of a state, I'm talking about the common law. That is the law of Illinois. That is the law of Missouri. That is the law of all the 50 states. 49, Louisiana is half. What about Ohio? Let's go to Ohio, baby. Look. They say it again. 1990, when Illinois became a state, they adopted the common law and statutes of England as the rule of decision. Let's go to Google real quick. Law means rule of decision. What does law mean? It means the rule of decision. So if I ask you what the law of Illinois is, you have to say the common law. The common law of England. What about Ohio? Let's go to Ohio. O-H-I-O. O-H-I-O. So are we Americans or something else? If you were born in one of the 50 states, that state is your nationality. So if you were born in Michigan, you're whatever Michigan people call it themselves, Michiganders or whatever, Michiganites or something. I don't know what y'all call each other. If you were born in Texas, you're a Texan. If you were born in California, you're a Californian. If you were born in New York, you're a New Yorker. in any part of the state. That don't just apply to people in the 5 boroughs. Ohio. Ooh, I posted this yesterday. Michiganders. There we go. I told you earlier, the people from Indiana, they're called Hoosiers. The Ohio Supreme Court said that Commonwealth state with common law. What are you talking about, bro? You got to be on. Yeah, everybody say bye-bye. Ohio said they're citing, I tell y'all this all the time, whenever you want to start studying the common law, you can start with these books by a guy named Edward Coke. It's spelled Coke, so C-O-K-E. So Edward Coke, just to help you spell it better. He wrote, I think there are 6 books. Thomas Jefferson said, if you want to start learning the law, he said, start with Edward Coke's Institutes on the Laws of England. And the Institutes on the Laws of England were written by a guy named Edward Coke in the 1600s. They were in 4 parts, but I think they came out in 6 books. And he was at that time the most brilliant mind on English law, right? So the Supreme Court of Ohio is citing Edward Coke. And they said that the Christian religion is part of the common law. He said, he's telling the history of this. He said a Saxon law of a king, I can't pronounce his name, said in these words, which is all Latin, which I obviously cannot read. It says, here note, by the way, that no merchandising should be on the Lord's day. And I'll read it all the time, but the Supreme Court of Tennessee, the Supreme Court of Florida, I just found the other day the Supreme Court of Arkansas said that the common law of England is derived from the scriptures. That's why they don't talk about it, because they don't want you reading those things. All right, Ohio. Let me close some tabs. The Supreme Court of Ohio said the common law of England founded on the common experiences of the people. They said the concept of the common law, which the framers believed important to be preserved as a protection for the individual and a restraint upon possible abuses of judicial power. Why do we have a trial by jury? For restraint upon the abuse of judicial power. They said Ohio was carved out of the original Northwest Territory, consisting of the following states: Ohio, Michigan, Indiana, Illinois, and Wisconsin, and a portion of Minnesota. Each drew up a constitution as a foundation for their own laws and government. And they said that in each of them, the inhabitants shall always be entitled to the benefit of judicial proceedings according to the course of common law. What does that mean? It means a trial by jury, where the jury are the judges. And they said that the common law of England furnishes the rule of decision in the courts of this state. So what's the law of Ohio? You can fill out the Bureau census if you want to. It doesn't. Technically, that is a that is kind of a constitutional thing. What about Texas? Come on, let's go to Texas, everybody. See why they don't talk about this common law stuff? Because it's the real law. Let's see, who is this? A Texas court said that the American people are the sovereigns, and in them is lodged all power, and the agencies of government possess no authority. They said Texas formally adopted the common law of England. Okay, yeah, I'm reading it right. All right. Texas formally adopted the common law of England on January 20th, 1840, with it taking effect on March 16th, 1840. They said the historical and legal basis for this adoption lies in both constitutional mandate of the Republic of Texas and subsequent legislative acts. They said ubiquity in Anglo-American law. The common law doctrines were made a part of Texas law from the beginning. They said in 1840, the Republic of Texas adopted the common law of England as the rule of decision. And then they say it again in another case. That's the Supreme Court of Texas in 2025, I believe. 2025 in May. They said the common law of England, in another case in the 60s, said was made the rule of decision on January 20th, 1840, and is to continue as such. So if I ask you, what's the law of Texas? What's the law of Michigan? What's the law of Massachusetts? What's the law of Florida? Isn't this fun? Let's go to Florida. Why these scammers on the internet don't be talking about the common law? Because they don't know it, or they're feds and they're not supposed to be talking about it. The Supreme Court of Florida said no free man shall be hurt in either his person or property unless by lawful judgment of his peers or equals. What? Lawful judgment? Who are the judges? In Florida, who are the judges? They said the Magna Carta is in force in this state as of November 6, 1829, by adopting the common law of England. They said on November 6, 1829, the territory of Florida adopted the common law of England. And they said, the Supreme Court of Florida said that the right of a trial by jury shall forever remain inviolate. In the same case, they say that lawful judgment only comes from the people. So any judgment that didn't come from the people, was it a lawful judgment? Just a question. Just a question. Because they said, not a guy in a black robe. They said, by the lawful judgment of his peers. They're actually citing the Magna Carta. They said this is based on Chapter 29 of the Magna Carta, or Section 29 of the Magna Carta. Let me see here. They said that the Florida Constitution has to be made in reference to the principles of the common law in ascertaining the meanings of the Florida Constitution. They said the Constitution should be read in light of the common law from which our system of jurisprudence comes. The Supreme Court of Florida said the common law is in force in this state. They said statutes and constitutions in this country should be read in light of the common law from which our system of jurisprudence comes. I was citing a book, and then the book cited the Supreme Court of Florida. The Supreme Court of Florida said Florida has a practice peculiar to a jurisprudence predicated on the common law. They say it like no other state has the common law. Why? Because Florida is its own thing to themselves. They know other states also have the common law, but they said when we talk about Florida, we act like nobody else exists because Florida is its own thing. It has its own flag. It's got its own Supreme Court. Technically, Florida has its own Air Force. Right? Florida Air Guard or something like that. I don't know. The Supreme Court of Florida said our Anglo-American legal tradition. Why do they say that? I just learned why they say that. Anglo-American legal tradition. There's a guy named, he's dead. His name is Supreme Court Justice James Williams. James Williams, or Wilson, James Wilson. He was a Supreme Court judge in D.C. He said that, okay, so when you study the timeline of the common law, you have to, okay, I don't know how to say it right, but everything after the year 1066, so after William the Conqueror, is not technically the common law. So technically, you can use it, but that it's not as important as I'm saying it. The Magna Carta is technically not the common law. Technically, anything before the year 1066, before William the Conqueror, is the common law. They define the common law as the ancient unwritten law of England. They say the common law are the usages and the customs of the ancient unwritten laws of England. Okay, well, where did they get the unwritten part from? They would have got it prior to William the Conqueror. They say the common law is technically anything from, technically it can go back before Christ. So I got it in the year 510 BC, but let's just say after the resurrection of Christ, they start with these people called the Druids in England. And then from the 100s to the 200s, you got the Druids, and then about 300, I'm just giving a generalization, about 300 to the year 1066, you got these people called the Angles and the Saxons, and they were the primary force of the common law in ancient England, right? I cited earlier, those Angles and those Saxons say they trace their history all the way back to the people of Moses. And there's another book I said that said there were white people and black people in ancient England during that time period. So, but when we talk about the common law, technically, James Wilson said, Supreme Court Justice, he said our common law comes from more of the Anglo-Saxons than that of William the Conqueror. So they, over the years, named it the Anglo-American legal tradition, because they could have said the William the Conqueror American, I don't know what they would have called themselves then, the Normandy American legal tradition. No, they said no. The common law technically comes from before William the Conqueror. And you would have to study the first 1,000 years before William the Conqueror to know, in England, to know what the real common law is. And so they say, the Supreme Court of Florida said that our Anglo-American legal tradition, we term the common law, is an English institution. They said it is not a fixed body of well-defined rules, but rather a method of juristic thought or the wisdom of mankind. It is a doctrine of reason. And it says its rules were promulgated in feudal times when slight value was attached to life, liberty, and property, and when commerce was almost unknown. They said, yada, yada, yada. They said we are, talking about us, the states, are more a common law country than England is today. The Supreme Court of Florida said we're more of a common law country. Why? Because the current England or Britain or United Kingdom, whatever you want to call them, technically you go to their website and go study the history of their kings. They don't go before William the Conqueror. Everything that they count as their lineage starts with William the Conqueror. And they trace it all the way down to whoever's the current king. They got a website of all their kings. They don't go before. They don't mention the Anglos and the Saxons at all. And so the Supreme Court of Florida said we are more a common law country than England. Why? Because we adopted the first 1,000 years of the common law as our primary law. And that would be before commercialism and fake paperwork was introduced in England. Remember, we broke off from them for a reason, and it was because they were not obeying the common law. Right? All right, so the Supreme Court of Florida said our Bill of Rights comes from the common law. They said the common law of England is to be in force in Florida. They said the common and statute laws of England down to the 4th day of July, 1776 are declared to be of force in this state. And they say it again in another case. They say even where the legislator acts in a particular area, the common law remains in effect. They said there is no change. They said it will not be held to change the common law statutes. Where can I read what you're reading? At the top of my TikTok page is Patreon. And I put all my research there, or most of it. Most that I think is helpful. And I'm just reading everything I've read from all these states. I don't live in none of those states. I've been compiling information so that whoever wants to truly prove it can prove it. And these all come from the courts. Because you start studying the common law, they say, okay, well, how do you find the common law since it's unwritten? What does unwritten mean? It means it's not in the statutes. The statutes apply to the corporation, applies to the government. The unwritten part applies to us. That's why we have a trial by jury. That's why we got due process of law, right? So, the common law is the law of all the states, and they just ignore it every single day. That is the real law. I told you, let me see. I told you Florida said that it came from the scriptures. Watch this. Florida said every system of law is generated from some religion. They said the common law comes from, or the common law comes from the Christian religion. Its roots go deep into that system. The Christian concept of right and wrong, or right and justice. You see why they don't talk about the common law? You see I'm not crazy, I'm not a lunatic. There's a reason they don't talk about the common law. Because the common law restrains government. Civil law, which is the opposite of the common law, gives the government more power than it is supposed to have. Does that make sense? Florida said states of the Union still possessing attributes of sovereignty shall be immune from lawsuits without their consent. They said Florida is immune to lawsuits. Congress, federal Congress, has no authority to subject a state to the jurisdiction of a federal court. They do it every day, don't they? They said, the Supreme Court of Florida said, Florida has retained the status of a sovereign. They said this in the 1900s, y'all. They said Florida was admitted into the Union on equal footing with the original states. The Supreme Court of Florida said we should keep in mind that sovereignty resides in the people. They say it again. They said that in 2000. They said the Florida Bill of Rights became a part of the federal constitution on December 15th, 1791, but it had been in Virginia on June 12th, 1776. They said the Bill of Rights has its grassroots in the Magna Carta of the year 1215, and its declared purpose was to guarantee the personal and political liberty of Englishmen. And here it means that sovereignty resides in the people. They said this is attached to all state constitutions. So can police pull us over? Yep, if you've given them information. If you've given them a contract, they can. If you show up on their computer, they can pull you up, pull you over. They do it every day, don't they? See, what they don't show is when they can't pull you. They never show their losses. That's what's hilarious. They never show their losses. Redo what? Well, there's nothing to redo. You're sovereign. Don't create an injured party. Don't get in fictitious contracts with corporations that take away your rights. There's nothing to redo. The question is, can you survive without the corporation? Why would you want to redo the Constitution? The Constitution is not talking to you. Constitution tells a government what they can and can't do. Now, I just told you, the law of Florida is not the Florida Constitution. The law of Florida is the common law of England. Oh, this is so fun. The Constitution creates a government. And I read it earlier. You may not have been on the live, but you can't interpret the Florida Constitution without reference to the common law of England, which protects the people's rights. The problem is our ignorance. The problem is not the Constitution. The problem is we've submitted to a fictitious corporation who now controls our reality, because if we would admit it, we don't have any real skills to live outside of commercialism. That's really the issue. We can't live without electricity. Whose electricity is? It ain't our electricity. They created this. And if you can't make it without their commercialism, well, you wouldn't have made it no way. See, if you can't make it without a refrigerator, you're not going to make it. You might as well stay in the system. If you can't make it without a washing machine and Wi-Fi, you weren't going to make it no way. Because the same way we have to interpret the Constitution the way they originally designed it is the same type of life we're going to have to live in order to keep from being subjected to it. That's why they got these people in the Northeast called Amish people. They're doing just fine. No Wi-Fi, no electricity, got clean clothes, fresh food, no diseases, work when they want, don't work when they don't want to. Yeah, they're doing life just fine. Go where they want to. I seen them in Miami one time. They got off a tour bus like they was fresh out of a rap video. I was like, not the Amish. They got off of there, boy, with the little house on the prairie outfits on. I said, let's go. Who is he? He was a dictator. Who are you talking about? What states are we from? What's up? What states are we from? Okay, yeah, we're not talking about him. So everybody say bye, Cody. Don't get blocked. I don't care. Y'all don't pay no money to watch this. Get blocked. We don't discuss politics. We talk about the law. California, Arizona. What's the law of California? Here we go. What's the law of Arizona? Let's go to California and Arizona, everybody. All right, Arizona. Excuse me. Actually, I don't know if I have Arizona. Nope, I do. They said the common law of England shall be the rule of decision in all courts of this territory. They said we adopted it. They said the common law of Arizona includes the English common law down to the time of the severing of the union between the colonies and the mother country. They said again in 2004, the common law of England shall be the rule of decision in all courts of this state. They said that in 2004, Supreme Court of Arizona. They said in 2020, the right to a trial by jury shall remain inviolate. And they said that's based on Article 2, Section 23 of the Arizona Constitution. Let's go to California real quick. California's nasty. Most of the stuff I've learned is from California. I got so much stuff on California, I don't even know where to start. Let me close some tabs, sorry. Supreme Court of California said the common law is still the law of this state. They said we never got rid of it. I don't know what these people are talking about. They said California rests exclusively upon the common law, which was made the rule of decision at the time of the formation of this state. They said the common law having been adopted as the rule. Why don't they talk about it? Because they don't want you to know about it, all right? This is not conspiracy. This is for real. Because you start learning this common law stuff, you're like, oh, somebody lying straight to our face. They fought the Revolutionary War because they were trying to take away the common law of England from them. That's what's hilarious. And they don't talk about that common law at all. They act like, oh, and people tell me all the time, brother, I went to court. They said they don't do the common law no more. They said that was in old Britain. I'm like, there's somebody breaking the law. Because California said they're supposed to be resting exclusively upon the common law of England. We know that don't happen. They said again, the common law having been made the rule of decision in this state. They said, what's the law of California? What's the other one? I got a bunch of them. California. Let's see here. Boom. California or common law part 2. They said again in the 60s. The common law of England shall be the rule of decision. They said California. They said in another case in the 84. They said California already incorporated the common law of England. What are you talking about? They said, I'm talking about all different periods of history. 1920, 1960, 85, 62. That came from when they ended common law marriage. They never ended common law marriage. There's no such thing as ending common law marriage. Y'all just be making up stuff. It's literally in the California Code. You don't even have to believe me. You can go to the California Code. They say common law of England is the rule of decision in all parts of the state today. I'm just telling you Supreme Court because I don't study codes because they're not the law. Then are we supposed to own property or rent? You're supposed to own property. You're supposed to own land. Property is a fictitious term. You're supposed to own land. They said, ooh, this is nasty. The Supreme Court of California said, in California, as in other jurisdictions of Anglo-American heritage, the common law is not a codification of rules, but it is rather the embodiment of broad and comprehensive unwritten principles, inspired by natural reason and the innate sense of justice adopted by the common consent for the regulation of government and human affairs. I say it again, the common law is the basis of our jurisprudence. Yeah, they never got rid of the common law, they just ignore it. Because of our ignorance. See, this is supposed to be spreading like wildfire because they're breaking the law every single day. Let me see, I got another one, I can't find it. California called themselves a Commonwealth. They said the California people, the people of California are entitled to greater protection. No, well, let me read the other one. It only says it in 3 sentences, but they say in this Commonwealth, yada, yada, yada. But California called themselves a Commonwealth. They said, and in another case, the Supreme Court of California said that the people of California are entitled to greater protection under the California Constitution than required by the United States Constitution. So what are you supposed to be studying? They said this is no revolutionary thing. They said the people of California are entitled to greater protection under the California Constitution than that required by the United States Constitution. All they talking about, constitutional rights, constitutional rights, constitutional rights. There's really 2 constitutions. Yeah, you're supposed to be studying your state constitution. They said this is no revolutionary thing. We're simply reaffirming the basic principle of federalism, that a nation, the nation as a whole, is composed of distinct geographical and political entities and independently responsible for the rights of their people. They said when the people adopted the California Constitution, they declared that the rights guaranteed by the California Constitution is not dependent on those guaranteed by the United States Constitution. How many people you hear? And you might have been one of them saying, oh, the 4th Amendment, the 5th Amendment, the 6th Amendment, the 10th Amendment, the 1st Amendment, da, 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 da. Those aren't your amendments. You have amendments. You have a Bill of Rights. Your state has a Bill of Rights. And they are more extensive and more expansive than the United States Constitution. Say no, it's not. Say it. Say no, it's not. Somebody try me. He's lying. He's a scammer. Watch this. Somebody, no takers. The Supreme Court of Georgia said, it is a well-recognized principle that a state constitution grants individuals more rights than those protected by the United States Constitution. They said the Georgia Constitution provides greater protection than the federal Constitution. They said the Georgia Constitution gives broader protection, grants a broader right, provides a more extensive guarantee, and is more extensive or more expansive than the federal Constitution. They said Georgia is not alone in providing its people with a broader right of privacy than that provided by the federal Constitution. They said in Montana, Tennessee, Kentucky, Texas, New Jersey have all interpreted their respective state constitutions as being more extensive than the United States Constitution. But I thought the United States Constitution was the supreme law of the land. It is. So when you go to Article 4, Section 4 of the United States Constitution, and it says that the feds are to guarantee every state a Republican form of government, what does that mean? It's right above my head. The Supreme Court of Delaware said, well, the people of Delaware enjoy more rights and more protections than the federal Constitution gives to them. But I thought we were... You have a Constitution, guys. You have a Bill of Rights. And you only live in one state. And your state's law is the common law of England. If you're in Louisiana, your criminal law is based on the common law of England. So how important is it that we pay attention to our state's constitutions? Does that make sense? Any questions? And this sounds crazy, but anybody not talking about the common law of England, I would question what they're talking about. And I'm talking about anybody, attorney, judge, scammer on the internet, Fed, whoever. Whoever's not talking about that common law of England, I'd question them. Yeah, I don't know about that. Well, they'll tell you right to your face that they don't do the common law of England, and then ask them where they get all the Bill of Rights from. All the Bill of Rights come from, all your states' Bill of Rights come from the common law of England. That's the only thing you need to be studying in the Constitution. You need to be able to trace all those back to the common law of England, back to England. How do you do that? What about Florida? You missed it, Tony. Sorry. The law of Florida is the common law of England. How will you find that? You go to your nearest law library, depending on what state. Let me see what states. Some states have encyclopedias. Not every state, but let me see, where's it at? Yeah, here we go. These are the states with law encyclopedias. California has it's called California Jurisprudence. Colorado is called the Colorado Law Annotated. Florida Jurisprudence. Georgia has two, the Georgia Jurisprudence or the Encyclopedia of Georgia Laws. Illinois is called the Illinois Law and Practice. Indiana is called Indiana Law Encyclopedia. Louisiana is called the Louisiana Civil Law Treatise. Maryland is called Maryland Law Encyclopedia. Michigan Law and Practice Encyclopedia. The Encyclopedia of Mississippi Law. The New Hampshire Practice. The New Jersey Practice. The New York Jurisprudence. The North Carolina Index. Ohio Jurisprudence. Pennsylvania Law Encyclopedia. South Carolina Jurisprudence, Tennessee Jurisprudence, Texas Jurisprudence, and then Virginia and West Virginia are called the Jurisprudence of Virginia and the Jurisprudence of West Virginia. Those all have categorized topics pertaining to your states. So when you go there, you would look up trial by jury. You would look up grand jury. You would look up, things that are in your state's constitution, primarily the Bill of Rights. And you would find those in those legal encyclopedias. So you could go to your nearest law library or library that has those books and just take notes, compile the information. That's how you learn the law. Because what's in these books? The books aren't important. What's important is they cite everything. They cite where they get their information from, and they'll all be from your state Supreme Court cases, because that is evidence of what the common law is. That's where you find it. That's why I've read you nothing but Supreme Court cases all night, because that's where you find the common law. The common law won't be in the statutes, the codes, the regular. That's not where you're going to find it. You're going to find it in the ancient unwritten principles of the people of those states. Well, except for Louisiana. Louisiana is founded on the civil law, so. But everyone outside of there. But if your state doesn't have a legal encyclopedia or a law encyclopedia, you have to try to find your state Supreme Court reporters or reports, which are their books. Now, it's a lot of them, but you can find a lot online. Try to find like volume 1 of the Wisconsin Supreme Court reports. And if you can download it, and then just type phrases like common law, Magna Carta, different phrases in your Bill of Rights, trial by jury, like try to, you'll find those different topics, and they'll have cases that address those specific topics. Does that make sense? So like if you live in Michigan, you got to go to the nearest law library, and you're going to search Michigan law and practice. The Magna Carta is on the Michigan government's website. They got all 63 citations of the Magna Carta on Michigan's government website. Why? Because the common law of England is the law of Michigan. And I ain't never been to Michigan, but I bet if I went to their Michigan law and practice, whatever they call it, encyclopedia, you're going to find nothing but Magna Carta citations that you can use before the jury, who are the lawful judges of Michigan or Florida, wherever you're at. You say, okay, well, this attorney's lying because the Michigan Supreme Court said X, Y, and Z. And they categorize a bunch of topics. That's what these law encyclopedias are about. Yeah, they got the entire Magna Carta on Michigan government's website. And then an attorney will look you dead in your face and say, no, we don't do that no more. Well, why it's on there? I would say that in front of a jury. Then why it's on their website right now? All right. Any other questions? I'm going to get up off of here. See, a scammer, he can just yap all night. I got to go read books. No problem. No problem. I have a YouTube channel called Constitution Academy. You'll see a black guy with no hairline. That's me. I normally do live on both of them, but I was only on TikTok tonight. And then I have a Patreon where I try to post everything that I find on there, and I prove where I got it from. If it's from a book, I'll upload the book. Or if it's from a court case, I'll cite the court case and put the link of where the court case is located. It's at the top of my TikTok page. It should be the only link at the top of my TikTok page. And it's $5 a month or $60 for the year. That will help me buy more books because this stuff is expensive. So, or if you don't follow the TikTok page, just follow the TikTok page. That'll help too. All right, tomorrow 6:30. Tomorrow 6:30. Central Time. So wherever that is for you. Tomorrow, 6:30. All right?